You know, it's funny. Sometimes the biggest fights in a neighborhood aren't about some huge policy decision. They're about the little things, right? That shared fence, a community garden, or, in this case, a couple of parking spots. And what seems like a tiny disagreement can suddenly open up these huge questions about how we all manage to live together. So let's dive into one of those stories.
Okay, so this isn't just some angry note left on a windshield. This is a real official case caption. We've got Judy Clapp as the petitioner taking on the Forest Trails Homeowners Association. Yeah, this little dispute didn't just end with a neighborly chat. Oh no. It went all the way to a formal administrative hearing, a full-blown legal battle over a patch of dirt.
So here's the question at the heart of it all. What happens when a parking spot that's been used for 20 years suddenly disappears? I mean, really, what happens when decades of tradition clash head-on with the black and white text of the official rules? All right, so let's set the scene. We're in this beautiful community, Forest Trails, out in Prescott, Arizona. And at the end of this quiet little cul-de-sac, there's this popular trailhead that goes right into the National Forest. Now, for years and years, residents would just park on this little patch of common ground right there to use the trail. It was just what you did. Until one day, suddenly, you couldn't. So, let's meet the two sides at the center of this whole thing. On one side, you've got Judy Clapp. She's been a homeowner there since 2006. And on the other side, the Forest Trails Homeowners Association, the HOA. You know, they're the ones in charge of all the common areas and making sure everyone follows the rules. So here's the spark that lit the fuse. The homeowner who lives right next to the trailhead puts in all this new rock landscaping right on that common area, completely blocking off the parking spots. And Judy Clapp's response? Well, she didn't just write an angry email. Nope. She filed this formal petition you see here with the state, which kicked off a whole official legal process. Okay, so let's break down Judy Clapp's complaint first. What was her argument? Well, for her, this wasn't just about losing a convenient parking spot. Not at all. It was about history and what she truly believed was an established right. And this quote from her, "It's been an established benefit, a selling point," really gets to the heart of it. In her mind, this wasn't just some random patch of dirt. It was an amenity, something that was part of what made the neighborhood great, a benefit that everyone who lived there had enjoyed for a long, long time. So her case really stood on three main pillars. First, there's the history, right? For over 20 years, everybody knew this was the spot to park. It was an unwritten rule. Second, she argued about exclusive use. Basically, that the HOA let one homeowner take over a shared space for their own private use, which isn't fair. And finally, just the practical hardship of it all. Now you've got this nearly 1-mile round-trip walk just to get to the start of the trail. And this really gets to the key definition at the center of her complaint: common area. The whole point of a common area is that it's for the benefit and use of all the residents. So from her perspective, letting one person landscape it completely blocked that long-standing shared use. But this leads to the million-dollar question, doesn't it? If something's not in writing, does tradition even count? I mean, does doing something for 20 years create an actual rule even if it's not in any official document? All right. So now let's flip the coin and look at the HOA's side of things. Their argument had nothing to do with tradition. It was all about the official rules, their legal duties, and, maybe most importantly, their responsibility to be fair to every homeowner. And really, this one question from the HOA's attorney pretty much sums up their entire defense. He asked Ms. Clapp, "Do you know of any provision in the declaration that guarantees parking? Basically, show me the rule. Show me where it's written down." Because, in their view, if it's not in the official paperwork, it's not a right. Period. So the HOA's defense was built on 4 main points. First, and this was the big one, there was no written guarantee. Nothing in the official document says anything about parking there. Second, the board absolutely has the authority to manage common areas however they see fit. Third, they said the landscaping actually solved problems. It fixed an erosion issue and even addressed complaints from other neighbors about noise and trash from all the parked cars. And finally, they made a really strong argument about fairness. And that fairness argument, it really hinged on this one word: hundreds. During the hearing, an HOA board member, Dean Meyers, was asked how many other homeowners had been allowed to landscape the common area next to their property. His answer was hundreds. So their point was, how could they possibly tell this one person no when they had told hundreds of others yes? It would be totally unfair. And on top of that, the board didn't just sit back. They took action.
They went ahead and installed new no parking signs, even warning that cars could be towed. It was a very clear statement. We're in charge of this space, and this is the new rule. So when you boil it all down, what you have here are two totally different ideas of what a rule even is. This was never just about parking spots. It was a clash of philosophies, right? The unwritten rules of how we've always done things versus the official written down rules. And you can see it laid out perfectly here. On one side, you've got the unwritten rule. We're talking 20+ years of everyone just doing it, something seen as a real benefit, a community tradition. But on the other side, you have the written rule. Absolute silence in the official documents, clear authority given to the HOA Board, and a legal framework they have to follow. That right there, that's the heart of the whole conflict. And the HOA's whole case rested on these, the governing documents. And we should be clear, these aren't just suggestions. They are legally binding contracts. They include the CC&Rs, that's covenants, conditions, and restrictions, that every single homeowner signs and agrees to. So for the HOA, it's simple. If it ain't in the book, it's not a rule. And that's precisely why it had to escalate to this level. This notice of hearing is proof. The state had to bring in an administrative law judge, and their whole job was basically to read those governing documents and make a final call on which rule wins, the written one or the unwritten one. So where does all this leave us? Well, this tiny fight over a few parking spots actually forces us to ask a much, much bigger question. What really makes a community a community? Well, this quote from the HOA board member Dean Meyers gives you one answer. We couldn't tell him no when we had told hundreds of other people yes. That's a vision of community built on fairness and consistency, right? The written rules apply to everyone equally, no exceptions. But then you have this statement from Judy Clapp's attorney, which paints a totally different picture. You're impeding homeowners from being able to use that common area in the way they have in the past. See, in this view, a community isn't just a stack of legal papers. It's alive. It's defined by its shared customs, its history, and just the way people have always lived together. And so that's the final question this whole case leaves us with. And it's a question you can ask in almost any neighborhood. So, what truly defines a neighborhood? Is it the rules as they're written on the page? Or is it all those unwritten traditions, the ones that really shape our daily lives? The answer probably says a lot about the kind of place you call home.